in my opinion. This is not a review. So let me tell you, let's talk first, test, okay? So you guys kind of know what you're coming into. You are going to get a corporation's essay, okay? I take that back. I say corporation. You're going to get a business organization's essay. So you're going to have an essay. you're going to have, and then you're going to have 25 multiple choice. Okay. I'm going to tell you right now, in my opinion, multiple choice are a joke in that they're too easy, in my opinion. But I didn't put any together, and Veronica was like, "Where's your things?" Like, crap. And you're gonna see them. You're gonna be like, okay. So that being said, it may not be the most difficult of midterms. All right, enjoy it because I'm not.
It'll be hard to.
This, what I gave you guys is not so much an outline with details for you, but what I wanted to do with this concise outline was to give you headers, right? So when you're thinking about these things and when you're thinking about agency, what type of agency is it? How is it created? What are the relationships between them? What are the duties between them? What sorts of remedies do they have? So this is kind of if you notice you've got an agency, which you might have. You might have a corporation. You might have an agency essay, right? This is your analysis, right? These are the things that you should be thinking about within that. Partnership's kind of the same thing. These are the types of things you need to be thinking about within those. So it doesn't have the answers here for you, but it definitely gives you a guideline for how you would attack an essay on any of these given subjects. Okay, so that was my intent because we haven't done that. We haven't talked about, okay, how do you attack a corporation's question, which could be a partnership question, or maybe it's an agency question. We don't know yet.
Well, why does this organization?
You have some structure, so use this as you can. This is going to be kind of the building block for me if I teach next year. And I don't know. We haven't gotten that far, but if John asks me, hey, you want to keep teaching it, I would probably use this and build out from here. Okay. The concise outline that you're like, these are what I would consider your headers. As you're going through it, these will be the headers that you're looking to discuss on. Other than that, let's we really these kind of initially they're kind of close with each other. I liked to follow the Barbary ones just because to me they're easy to follow. It's got all the information you need on there. All right, so if you're dealing with creation of agency relationships, right? Okay, you got to have contractual capacity. You got to have consent. You got to have what's your method of formation? Right? Is it by action? Is it operation of law? I like this layout because I think it guides you through the things that you need to know. As I was reviewing these myself, it did not strike me as we've covered this material. Yeah, I know we did, but the rules that are on either one of these outlines, they didn't flow from the cases to me, and that's probably because I didn't do a fantastic job of pulling those rules out and summarizing them for you guys at the time. But as I was going through these, I didn't think they were there.
I don't think a lot of them were in the cases. I think there were a lot like in the separate reading part of the notes.
Yeah. So here's where we're at right now. Aside from, just walking through these, you guys can do that yourself if you think it would be beneficial, right? We can do that. I would more. What are you concerned about? What are you? Right? It's if you have questions. I know that's a broad statement because.
I'm just confused about the whole voting aspect. Like, I don't understand any of the voting.
Okay.
Like, I know that for shareholders, you have to give them notice and stuff like that, and they can have a proxy, but other than that.
Now, are you talking about just how you vote, or are you talking about? Well, let's go through these, okay? I would go first to on the bottom of page 3. I would go to the voting rights first, and then let's get to proxies. That's how I would attack it. Okay, basically, you've got various different classes of stock, and they can have, just like it says, they can have full, they can have limited, they can have no voting powers, or they could go to Delaware, right? What review would we have in this class without some typos and some misspelled words, right? Just matches our textbook. So depending on the class of stock, it will articulate what rights you have. You cannot be asked about those unless it's given to you, right? So if the essay says, hey, let's talk about what the voting rights are, the essay is going to have to give you, well, here we've got preferred stock, we've got common stock, we've got preferred plus, right? However they want to classify them, and then they have to articulate what voting rights attach to those shares of stock.
So the question literally has to give us what kind of weight is in the different kinds of stock, and then the different weight that is attached to those different kinds of stock.
Has to.
Okay, I didn't know that.
Right. So that's why what you need to know going in is that basically voting rights within corporations are going to have to be articulated within their stock issuances paperwork or within their bylaws of how each one can vote. Okay. And for an essay, it can't ask you anything more than that without giving you details. It can't say, hey, so how could Joe vote this stock? Well, what kind of stock does he have? He's got preferred stock. Well, what does it say about preferred stock?
Okay.
Right? If they don't tell you what it says about it, you can't answer that question. Your answer would have to be, well, Joe can vote consistent with whatever rights are attributed to this class of stock. Period. And you can't elaborate further unless the facts give it to you. So as soon as you start reading and they start talking about different classes of stocks and different rights that attach to each, you already know, oh, I'm gonna have to start talking voting. Right? It's in here. They're giving it to me. So I'm gonna have to be prepared to talk about that. Okay, corporations may breach their fiduciary duties to shareholders by interfering with shareholder votes. Plaintiff has the burden to show that the board acted for the primary purpose of thwarting the exercise of a shareholder's vote. If the plaintiff does show the burden The board has burden of proof to show that there was a compelling justification for its actions, and if the plaintiff does not meet this burden, the business judgment rule applies. Since which we haven't covered, but
We have, right?
We
It just says that the business has to act in a
And it
reasonable
covers it in
manner.
this outline, it just,
Yeah.
it's just,
Right.
not there yet.
Right.
So I was under the impression that a proxy is a person that represents a group of shareholders with an interest at a meeting. That it's like, I mean, it's an idea or a plan, but it's embodied in a person that shows up. Is that not the case? Or
It can be.
It can be.
It can be.
Right, remember, we talked about voting agreements, which are kind of proxies, right? Except that most voting agreements are, I'm gonna vote this way and you agree you're gonna vote the same way. We both show up and we vote that way. But if one of us violates, we have a cause of action. You have trusts where you actually take your vote and it's in a trust.
Okay.
Okay, and you put yours in the trust. Now, we're no longer the actual voters.
No, the
The trustee would show up and vote all those shares for us. And then you have the traditional proxy where it's just like, hey, I'm not gonna be there, or I don't care. You want my vote? Here you go. You go vote.
So they vote
Right.
for, you know,
So they-
dozens of people or whatever, but
Right.
like, okay.
And remember, there was cases where individuals started soliciting proxies. Hey, can I have your vote? Yeah. Can I have yours? Yeah. Can I have yours? And then once they got a good number, then they showed up and tried to influence, exert some authority over the decision-making process. But you do have a traditional proxy, but you have all these other alternatives for ways that you can authorize someone else to vote your shares. Okay, and it can be a straight proxy, it can be a trust, it can be just a written agreement.
So some kind of statement of intent, basically.
Right.
Okay.
Right.
In all kinds of forms.
And it's really up to you if you, as a shareholder, if you want to enter into a proxy or not. I mean, you can just not vote your shares if you don't want to. But again, that's something that factually it's going to have to be given to you, right? There's going to have to be some discussion about, I have this right to vote, X number of shares, and I somehow give them to somebody else to vote, and they either do it consistently or not. So, right, I don't see how the essays don't telegraph what they want you to discuss, right? This really is going to be something that's going to
Be very specific.
Right? Was this corporation formed properly? Well, you're gonna have to talk about that, right? Were these shares votes, entered properly, right? How does this share get to vote compared to that share? They have to give you that information, right? So it really is fact driven, and it's gonna be telling. When you analyze it, when you're reading it, you're just going to be checking them off. Oh, I got votes. Oh, and if you remember these, right, these headers, right, and you talk and you get in there and you're like, oh, okay, I've got voting rights and eligibility, meeting required, right? You can talk about what are the rights of shareholders to vote, right? And that hopefully will clue you, what do they get to vote on, right? Do they get to vote on the day-to-day operations? No. Right? They get to vote for directors, and they get to vote for, depending on the bylaws, on changes to the to the bylaws. Right? They don't get to necessarily vote for the day-to-day operations. Right? Those are the directors that get to do that. So make sure you're identifying what it is that they're questioning. If it's the shareholders vote, and make sure what are they voting for, and as opposed to voting for directors, right? Remember we talked about how you would go about voting, and we did the cumulative voting as you get to vote. I don't want to get too deep in the weeds, but it'll have to give you that information, right? If it's cumulative, it's going to have to tell you it's cumulative, or else how will you know? Unless it just says, what are all the ways that these votes could be counted? All right, well, it could be, this way, it could be that way. They're going to have to tell you. If you've got one share, that gives you 200 votes, or whatever it is. You get to vote for 3 directors, you can vote for 9 directors, right? The math is going to have to be there for you to analyze.
Something that you're very unlikely to actually ask is a math question, right?
He's like, I'm not pulling out my calculator, so
I'm not pulling out my calculator. And I'm not going to tell you from where. I'm going to tell you, I'll give you this much. You are getting, for your midterm, you are getting a bar essay. Pull it off A-Bar's website.
It's like American Samoa's bar or something.
And all I do is I confirm, okay, we have covered this material. So you guys can do that. Aside from voting, what else are you worried about?
Is there anything specific to know about like the Securities and Exchange Commission? Other than they govern some stuff?
No. Who are the Security Exchange Commission? Look, this may be, and it's not, but this is like an example of the stupid questions I wrote. I was filling out the answer sheet for Veronica. I was like, did I really ask these questions? So, what does the SEC stand for? Securities and Exchange Commissions. B, Securities Enforcement Officer. That some of them really are that.
At least we'll get one right, hopefully.
So that's not one of them, but they're similar to that. So I only tell you that to focus on your rules, the headers that you're going to need for your essay writing, and the statements of law that go along with those. Don't worry about your multi-states. You all are going to do just fine on that. And when we're talking about the essay, it really is going to be read it, identify the issues that are in there, and then talk about the things that present itself. It could be formation, it could be the duties that they owe each other, right? It could be liabilities to third parties. It could be shareholder voting, right? Just know that you're gonna find your headers for analysis from the facts that it gives you. And I intentionally, probably because I'm feeling guilty about all the wisdom and wealth of information I've imparted on you guys this first half of the semester, It's not a difficult task. You still gotta identify, you gotta hit everything, but it shouldn't be the one that takes all your time. So that means you've got other classes that are you're gonna want to focus on.
I feel at least somewhat confident in the other classes. This one, I just feel like I'm treading water underwater.
You feel confident in like remedies?
I feel like I could pound the remedies question out if I had to.
Okay.
Corporations on the other hand, I can go look at it and go, that's all you're gonna get from this.
I believe this is a partnership.
It says they're incorporated, therefore I believe this is a corporation.
You're properly incorporated.
In order to be properly incorporated,
You have to be a corporation.
you have to be a corporation. If the question says it's a corporation, it's a corporation. The other thing that we never really covered that I don't remember really is can you pierce the corporate veil of a closed corporation in the same way that you can pierce the corporate veil of a regular incorporation?
Sure.
Or no, because it's.
I believe you can.
I would think that's when you do it.
Yeah, I mean, the reality is,
That's usually
right, I'm not gonna-
corporation you'd be able to.
what am I gonna get from piercing the corporate veil of Apple?
If you pierce the corporate veil and go after Tim Cook.
Well, if you're right, but you know what I'm saying. I mean, he's making so much, the salary. He's not using corporate assets he's not blending the two. He doesn't have to. It's probably going to be the closed corporation where it's mom and pop who are using the corporate credit card to buy groceries and pay their bills and things like that, where there's just a commingling, because there has to be a commingling, right?
Yeah.
So regarding that, we read a case that gave us 7, but then it looks like I cut and pasted the California rules in here, which are, I believe, are statutory. There's 17
what? Grounds for
grounds that,
Embarrassing.
and none of them are, like, it's,
None are determinative. Or
Yeah.
Determined.
right. They're all factors.
right.
Yeah, they're
Factors,
factors.
So,
for consideration.
7 or 17, just kind of find the ones and pull them out that are there and talk
Exactly.
about it.
It's have an idea of what type of things you're looking for, and they're gonna have to give you the facts.
Right.
Right? And the facts are, this person was using this asset or this account or what have you. You're gonna have to be given something to do that analysis there.
This much in debt, but only $5 in there.
Exactly.
Or well, I think it's more like the liability of this suit is $1 million, and they entered into a contract for $1 million while only having assets to total, $5, and
Well, they had
therefore they're
$1.5 million
undercapitalized.
They had $1.5 million in the account, and they paid themselves $1 million.
Right, yeah,
What are you
Yeah.
doing yourself for?
right.
You're gonna want to pierce to go after that $1 million that they now have as a personal asset. So it's one of those where you got to know, you got to have in the back of your mind what type of things am I looking for, but then you have to recognize it factually.
And then the 3 kinds of incomplete corporations, just because they're incomplete does not mean that you can pierce the corporate veil, right? Because the rules that I have for each kind of make it seem like, yeah, they're incomplete, but we're still going to treat them as a corporation to third parties.
Right.
Okay. So you still have to have the corporate veil piercing factors in order to pierce the corporate veil, even if they are an incomplete corporation.
Right, because most of the corporate failings and the rules that go along with those are to protect the third party against
The corporation.
the corporation, right?
Okay.
Let them out because, oh, hell, you can't sue us because
We're not acting on a corporation.
we're not acting. Well, no. If you are acting like it and pulling yourself out, like it appeared as if you would, they get to rely on that. You know, you have to get the burden on that, on your own failings. So it really is protection for third parties.
Rather than against third parties.
Correct.
Okay.
So,
Yes.
but no, those are good, like multiple choice type questions. You know, is this a
De facto nature.
or stopped? It's not corporation.
Then I guess what I just realized is an agency is a complete associate, like a business organization of its own. Like I thought an agency was just like the beginning of a corporate, like during the promoter stage. I didn't realize that they were looking at it as a business organization in and of itself.
Well, it's a relationship.
It's just a business relationship,
It's a business
right?
relationship, but it's a nice starting point because it lays the foundation for a lot of what follows.
Because all those authority parts actually apply for corporations and partnerships.
Exactly.
And everything like
Is it
that.
actual? Is it implied? Is it expressed? Is it apparent? What duties do you owe each other? Right? All of those things carry through to partnerships. Right? Are you liable? Right? Are you vicariously liable? Respondeat superior? Is this an independent contract? All of that, right? Frolics and detours, and those are all agency type concepts, but they carry on to principles, right? Those same concepts still apply, and a lot of the same duties and liability structures flow into the corporate. So it's just a nice way to introduce those concepts. But I would say much more than a business entity, it's a relationship.
Oh.
And it's probably more akin to a contractual relationship, though you don't necessarily have to have a written contract. It can be oral. But if you're the principal, you kind of have some authority. Right? You're making the decisions on how things are run, and right, this person is acting on your behalf, and right, what comes from that?
And a promoter is just basically an agent, right?
It's just an agent, but keep in mind the timing and what happens with those contracts, right? A promoter could be the head of the corporation before it's formed, right? And so if they go out there and they sign up these agreements with a corporation, and the corporation's not even in existence, well, who's liable for it? Right? Well, what was the intent? Right? You go out there and you set up an agreement for this guy to provide 2,000 widgets to X corporation, and he thinks he's dealing with you, then promoter, you're liable. If he thinks he's dealing with a corporation and the corporation is then put into place, then the corporation is liable on it. If the corporation comes into existence after the fact and they then want to ratify that prior contract, remember, for agency purposes, you got to have an ovation, right? They've got to have a new contract for the corporation to be bound on that.
Say again, when do you need an ovation?
You mean a promoter?
The promoter. No, the promoter's entered into the contract, right? And then the corporation comes in. For them to be held liable on a contract between the promoter and that third party, they have to ratify it with an ovation. Right.
They have to ratify with an ovation. It can be ratification or an ovation because, I mean, even a ratification still leaves the promoter on the hook.
That for ratification, they've got to receive the benefit and they've got to assume the liabilities. Okay, so it's in essence an ovation, right? But if, let's say, the promoter's already paid for the 2,000, which if they then accept it, okay, well now you've assumed the contract, but you don't necessarily have to pay the promoter. You're not liable to do that. So ratification is between the promoter and the corporation. Does that make sense?
Oh, I thought ratification was between the corporation and the third party.
That's an ovation because
I thought an ovation was a brand new written contract
between the two.
Correct. Ratification is just them performing. Therefore, we're saying we agreed to the terms that this person entered into on our behalf. Kind of like apparent authority when they didn't actually have authority, and the principal just says, "Oh, we're going to do it anyways."
Right.
Okay.
Yeah. Now keep in mind when you're talking about agency ratification, that's just, hey, I know you collect books and you like books written by that lawyer Pete Nolan. I found a rare Pete Nolan book and I bought it for you, and here it is, and it costs $30,000. If the principal takes that in and says, "Oh, thank you," and takes the benefit of that, then they have to pay you for it, or they say, "I didn't tell you to do this. That's your book. You didn't have the authority to do that." So ratifying in the agency sense is just accepting the benefits of the bargain, and then now you've assumed through the acceptance the liabilities without any formal writing, right? In the corporate sense, you need that formal writing. That's when you need that novation, right? To really let the promoter off the hook. Okay. Promoter's a little bit different than, just your principal agents, see theories. Same concept that kind of carries through, but it's for the promoter to be completely let off the hook. I believe you need a innovation. I don't believe ratification lets them off the hook.
Have we covered ultra vires acts? You're not yes.
I have it in my outline.
Well, ultra vires is
Beyond the person's ability, like as an officer or whatever.
right, or beyond the scope of your corporation, right? If your articles of incorporation says we are incorporated to make and sell cat food, right, and you start making and selling dog food, technically those are ultra vires acts, right? Because that's not what you're in business for, right? When you form this to make and sell cat food,
Right.
That's why a lot of articles of incorporation now say to engage in any lawful business activities, right? Because they don't want to be limited. Yeah, maybe we are incorporated to provide DJ services at weddings, but if we put that and then we want to start offering a photo booth, well, we can't do that because is that DJ services or now we're getting beyond that. So they make their business statement broader.
Right. See, I don't remember. We covered that?
Yeah, because I have ultra vires doctrine states that a corporation can only do those activities that they outline in their articles of incorporation.
Yes.
And then under that, I have default is to state any lawful business. That way, the corporation can do any action outlined under the state's code.
So I understand that, but what happens? Like, is that person individually responsible for the
They can be, or the shareholders can
bring a derivative action, right?
Yeah,
Against the
to
corporation.
Okay, to stop
to
it.
undo those acts.
Okay.
But I'm saying I bought Stockton here because I love cats. And if you're gonna start working for dogs, I hate cats. I'm a dog, so I'm gonna sue you for it.
Or it's not a derivative action, right? Because a derivative action is the shareholders on behalf of the corporation against the
That probably
corporation.
would be a derivative action. That's
Or
why I
is it
was
just and then if it's just the shareholders against the corporation, that's just a regular
That's just
civil
a
action?
that's just a civil action against the corporation. Right? Derivative is on behalf of the corporation
against the corporation.
against it.
Is it against the corporation or
Or it
against
could be
the
against-
share
it
or
could
not the
be against
shareholders,
the
the directors?
It could be against a third party.
Oh, it could be against a third party too.
Right. So it doesn't have to be against a corporation, but it could be against a director or it could be against a third party. So it's but ultravirus is just beyond the scope. And it can describe the actions of a corporation. It can also describe the actions of the actor. Right? If they're engaging in behavior that was beyond the authority granted to them, you will hear this, he was acting ultravirus because he's acting outside of the scope of what he was allowed to do. But in the
And is
corporate
is
sense,
corporation held to, corporation's not held to ultraviolet acts, right? Or when would they be? Like, is that with ratification, like?
no, they would only be held to them if somebody challenges it. Bottom line is that if you're in business to make cat food and you start making dog food and nobody objects, nobody challenges that, then you make dog food, right? And then it's like, okay,
See, I was thinking about it more like, all right, so we're incorporated to make cat food. We start making dog food. The dog food contract with a third party goes sour. You know, I'm in this bad contract for dog food. The corporation looks at me and says, "What the F are you doing?"
right?
Am I on the hook for the dog food contract because I'm acting ultra-virus?
Potentially,
Potentially.
but it's right. That's when you gotta start looking at, did you have the authority to enter that contract? Right? Did the board grant you that? Did you have the apparent authority? Did that person think they were acting with you, or did they think they were signing a contract with the corporation? Right? So then you have this whole authority analysis, and what was the basis? If they thought they were dealing with the corporation doesn't get to get out of it by saying, "Oh, so we acted ultravirus,
Right.
so we've got to end this." Right? Somebody's gotta challenge it. Okay, and it could be a director, it could be a shareholder. Somebody's got to say, "Wait a second, we're acting in a way outside of our articles in the corporation. We're not allowed to do this." Right? And that's if your articles in the corporation identify limitations on what you can do. Right? You said the default is, if you don't put anything, the default is any lawful business. Right? So if you don't put those limitations in there, but if you do put those limitations in there, then you can be held to those. Right? And it's typically internal, not external.
Okay. Typically internal. Okay. Sure.
So the corporation would just go after the person who entered into that contract, but they probably wouldn't be able to get out of that contract.
Right.
They'd have to fulfill the contract as a third party, but then
Correct.
they can go after the director who entered into that contract when they shouldn't have.
Exactly.
Fair enough.
Or the shareholder could come in and say, "Look, corporation, what are you doing? You're not allowed to do that." You know, and they can try to undo it. And maybe it doesn't matter if it's a good contract, bad contract. Shareholder says you're acting outside of the parameters of the corporation, and I want to prevent those acts. They can file suit to do that. What you got? Quiet. I know you're quiet tonight.
This is where I gather information on.
He already knows it all.
Yeah, exactly.
He's been studying.
And then LLCs are just the corporate protection with the partnership duties, right?
Yes.
And then but you can waive your duties except for the duty of good faith.
Correct.
Because I remember there were certain things you
Yes.
could waive and stuff.
Yes, there's certain ones you can waive.
Except the duty of good faith.
Correct. Correct.
But other than that, I mean, it's still basically, you get the corporate liability protection, but you're still basically a partnership.
Correct.
And then do we need to know like which agencies we filed the documents with, like the articles of organization in a partnership gets filed with this state agency, articles of incorporation get filed with this state agency.
As long as you know that you filed.
That they filed them with the state, no matter where.
You're good.
Okay.
As long as you know that you're filing with the state, you're okay. Okay. You're not going to have any such.
The Secretary of State is aware.
Oh, okay. I may have misspoke reading, Mr. Vincent. It says ratification. This is under the agency outline. The principal can be bound to by contract if the principal later ratifies the transaction, and methods of ratification include acceptance of the benefits, silence if there was a duty to affirm, and suing on the transaction. So if you sue on it, you now ratified it for yourself.
But that's only under agency, not for promoters, right?
Correct. Correct. And just remember the small little details about, when you're talking about agencies and promoters, and are you dealing with disclosed, unidentified, undisclosed, and things like that. So again, fact-driven. I'll have to tell you, Joe was talking to, Mike about setting up this corporation or about setting up this contract, and he was working for somebody's behalf, but he didn't tell, Mike that he was working for somebody. The facts are going to have to be laid out there for you to do the analysis. Oh, well, he would be considered. This is an undisclosed principal, and right when they're undisclosed, right? Then, what are the ramifications of those? So, I would, just make sure you know the little details. That was Corey points on your multi-states. And I would look at these and be able to speak a little bit as to each one. Right? If you look at it, you're like, okay, creations and types. How do you create a principal? Okay. Contract oral, and as long as you go through and you're not, I can talk on that, right? What are the relationships between what are the actual parent, inherent authorities, right? What are contracts arising out, right? If you can, just as you read these, if you can identify, ratifications arising from agencies. The principal can ratify by, right, accepting the benefits, staying silent if they had to affirm, or suing on it, right? So as you go through these, if you're able to just touch on them, you're going to do just fine on the exam, because then you're going to be able to expand on that factually with what the test gives you. and do your analysis from there. Well, what else you got? What's concerning you?
No.
You good?
Yeah, I mean, I have some things to learn, but.
Well, me too. I'm right there with you. As I said, we can go through these, but you can go through them yourself. And my guess is probably going to be more beneficial for you guys to go through them. It makes sense for yourself. If you have questions,
I got them out of the way during class period this month.
if you do, you guys got my email. Shoot me an email, and I'll respond to you. I'm going to be proctoring Saturday morning, so if you guys want to throw some daggers at somebody, I'll be there. So you can, I'll see the looks, and I'll say, okay, yeah, they must be doing a corporation question. I mean their business organization question.
It's probably a partnership question.
It may. I'm telling you, I'm correcting myself because I don't want you to misconstrue that it's a corporation question, right?
It may not be a corporation question.
It will be a business organization, right? It could be a partnership. It could be an LLC. I wonder what I said.
It could be a sole proprietor.
Accidental
A sole proprietorship is somebody who does shit on their own for their own benefit. They're one and the same. Therefore, they have the highest duty to themselves.
And what are the benefits of a sole proprietor?
There is no benefit to
do whatever you want.
You have all the liability.
Although you have all the liability as well for whatever the hell you want to do.
You don't get so big as a sole proprietor before you lose our money to a lawsuit somewhere.
I don't know. We see sole proprietors usually like an appraiser. Well, often like they'll be doing business as Will Sanderson appraisals.
Mm-hmm.
Same with gardeners and poolmen and
Yeah.
realtors.
You just go to the city, get a business license, and open up your ice cream cart.
Yeah, get your fictitious name statement if it's
I don't do all
first
that,
name,
but
last
just
name,
saying, like,
Pay your $25 to the city, and
I'm once
You're a
like a
businessman.
super big national ice cream guy. As a sole proprietor, keep it like nationwide. Because your license is like limited to the city.
Can you have employees as a sole proprietor?
Yeah.
I guess so. Yeah.
My parents were sole proprietor up until they decided to incorporate.
See? At some point, you're gonna want to incorporate.
Yeah, they did that for liability issues.
Exactly. That's what I'm saying. Like at a certain point, it's not really like a huge sole proprietor that I know of.
No, I don't think there is any huge sole proprietorships.
I just looked at the essay, and I want to stress for you:
That is a business.
think
organization.
business, don't think
Corporate.
corporate. Maybe it's trying to get you to identify what the hell it is.
What is this business?
Oh, could be this. Could be this.
That way, we have to learn all three of them. That's how
All right. You'll have fun with it. I liked the question.
Just like the Star Wars one that they had fun with 4 years ago.
Yeah. No, this is.
it's gonna be the Empire.
Right? It's not.
And we had that, by the way, didn't we?
We had it as a practice question.
Yeah. It wasn't so bad.
It's gonna be the Empire.
Now, is this business opened up under the laws of America?
I did not write this exam. I'm telling you, I just picked it out of the ones I found, And I said, I like this one.
It's under Puerto Rico's business organization.
I should have made it to like someone at the Death Star subcontracts to like someone to make the heating vents.
Death Star Incorporated.
You know, I don't know if you guys
just
remember
play general rules.
the Field of Dreams practice one.
No, we didn't do that one.
You didn't do that?
No, but I think that was before us, but we didn't.
Yeah, I just had them do that this past Saturday, right? The Field of Dreams question, and they're like, "But they're ghosts," and I'm like, "The facts don't tell you they're ghosts. Why are you assuming?" Well, they are in the movie. I'm like, they're just names,
I get so confused by that.
right? They're just folks, but they're ghosts. Where does it say in here they're ghosts?
Cool universe. Just
Right? It doesn't. And they were saying, well, Dr. Graham was a baseball player. Like, but it doesn't say that, right? In the essay, it said she fell. Fortunately, a doctor was on scene. Dr. Graham approached and helped her, and he said, "Why?"
It's gonna be fine because I've never seen the movie. So.
and they're, yeah, they just get way too confused. And that's why you guys get, you know, Petunia and Delilah, you know, are having a flower competition. So, all right, guys, if something comes up and you want to run it by me, feel free. Okay.
Good.
I'll be here early, having my donuts and coffee before test time.
It starts at 8:30, right?
Yes.
Okay.
Yes.
So you need to be ready at 8:15.
I will be here at 8. I mean, that's just how I am.
If you want to have a good seat.
Yeah, that's what I want.
Right?
You sit right there just to troll them.
Yeah, sit in your seat.
No, we're probably going to be in the trial courtroom
Oh, no.
because we have 3 essays like everybody else.
That always annoys me.
What are your other essays? Remedies and
Remedies and community property.
And all that I really know is the difference between community property and separate property. So hopefully that's the vast
That's like
majority.
90% of the class.
I know, it
Is
is.
this mine or yours? Yeah.
That's 99% of the class.
Contract for it?
Is it mine or yours? When is it mine? When is it yours?
The answer is what's yours is mine, and what's mine is mine.
exactly.
Damn straight. That's how it should be.
Unless it's not.
At least back in the olden days when they got married.
Oh,
Nowadays,
Bill,
it's what's hers is hers and what's his is hers.
yeah.
That's the nowadays.
In the good old days, they were property. They're just more
Yeah.
Well, as
Unless it's
under the
dead.
law, the woman
No, unless it's dead, then it's his.
you should just start with that. Under the law, women are property.
Oh my god.
They're either the property of their father or the property of their husband.
Well, we don't have any case on it.
They can't. Oh,
That's a good law. That'll get you a quick F.
That'll just, you know, it'll see if they actually read your essay.
Yeah, I know, right?
There you go.
That's one of your. Actually, read these. Just throw on a grade on this.
I like you. B. You clearly didn't read what I wrote.
Here, about, I want to say it was about a week ago, a guy won a contest by reading the fine print of his insurance policy.
Yeah.
The insurance policy had put like a contest, like if you do A, B, C, and D, you win like $10,000.
Oh, wow.
And he reads the fine print of everything. He read it. He saw the contest in there. He did what he was supposed to do, and he won it.
Yeah, no, there's actually
That's awesome.
there's a lot of businesses that have them in like their terms and agreements and stuff like that because they know nobody reads them. And that's like the 4th one that I've heard of.
Yeah.
I think Apple had one in theirs too, or Google had one in theirs, and they won like almost $1 million. And I'm like,
This guy got like 10,000, but still, like, oh,
That's a lot of money, yeah.
I'll take 10,000.
maybe like Julie Bornstein that sits there and reads every line of her car rental agreement before I take the
Or
car.
so she claims.
What?
Or so she claims.
I kind of believe her. All right, well, thank you.
All right, guys.
Thank you very much.
Yeah, we took that off.
Yeah.
We also took it back up to 75 because it was at.
It is off.